Yes. Hello, everyone. Can you all hear me? Can I get some responses in the chat box, please? If I'm audible. Okay, I'm still waiting for your responses, folks. All right. Great, let's get started. Okay, welcome to NLTI everyone, and we are going to continue our series of legal reasoning just like every Friday. So today we are going to understand how can you score well in the legal reasoning section. So CLAT is around 7 months away. I'm sure you all are preparing well for the same. All of you are really excited for your preparation, and I hope all your preparation is going really well. Now, one thing that a lot of students do not correctly know is what should be the right preparation strategy for scoring well in this section. Legal reasoning in itself is a highly scoring area, right? Why it is so? Because the questions are of a very similar nature. Usually the pattern remains the same. And if you are well prepared and if you can anticipate the questions properly or the pattern properly, it becomes really easy for you to answer all the questions correctly. Now, how that has to be done is something which nobody really talks about. And most of the time, students, they start preparing without any right direction, without any right preparation strategy. Now, to avoid all of that, right, so that you do not waste your time, you do not waste your effort and your resources and things which are redundant, which are not necessary. We are going to today understand what is going to be the right strategy for you to start to prepare for CLAT and especially to score well in the legal reasoning section. So without any further delay, let us get started. First things first, let us understand what are a few myths about legal reasoning. So, see, it is students who are just starting out their preparation. Sometimes they're not sure about what is the level of preparation that is required, and they start cramming and memorizing all the laws, which is not necessary. So it is not a test of your legal knowledge. See, you are going to be appearing for CLAT after your class 12th, right? So if you do not have knowledge as of a lawyer, that's absolutely fine. The consortium is not trying to test how well do you memorize, how well you can memorize laws. It is much more about how well you understand laws. So if you do not have any prior knowledge about law, that's absolutely fine. Secondly, like I've already mentioned, you do not have to memorize all the sections. That's not the case. And third is that even if you do not remember landmark judgments, major judgments, or you're completely unaware of the same as well, that's absolutely fine, right? CLAT is not going to test your existing knowledge on law. So what it is really testing? It is testing how well you can read and understand comprehensions. See, now it is a passage based exam, right? All the questions are going to be associated to some or the other passage. So how well you can read, how well you can analyze all those things that you are reading, that is something tested. And how well you can apply the principles that are there. Legal reasoning is going to have a lot of, in the legal reasoning section, the principles are going to be discussed in the passages. So the reading comprehensions that are going to be there, some or the other principle or policy or law or rules that will be discussed in the same. So now how well you understand those principles, how well do you understand what the laws or the rules are, and based on those understanding, how well you can answer those questions is something which this exam is really going to test. And finally, how well you can reason your answer. See, you might have an application based question and the options might look really identical to you, and there's a possibility that you'll be a little confused. So in that case, you have to find the appropriate answer by justifying the options properly, how well you can reason your answer. So right, for the same, you need to be logical, you need to be rational. If you are opting any answer, you have to be really You have to give a proper reasoning for the same. If you are not able to reason it properly, then it means that something is probably not right. Okay. All right. Proceeding ahead, let us understand what this entire section is all about, first of all. So, in the legal reasoning section, there are going to be 4 to 5 passages. Each passage is going to have some questions associated to it, right? Usually, what we have observed in the past few years, the weightage that has been around legal reasoning is 28 to 32 questions, right? So, if that is a lot of questions, by the way, this means that around 28 to 32 marks are there with this section. So, if you really score good marks, let's say 20, 25, 30 marks, then you have a lot of chances of getting much better rank, and it is doable. It is pretty much doable. It is not difficult to score these many marks, because otherwise overall the entire section is fairly manageable if you have the right approach, right strategy with you. And mostly there are three type of questions that are asked. First, as the principle based question, like I've already discussed, that the principles will be discussed in the passage also. Based on the same, there might be some questions regarding those principle itself. That means your conceptual questions can be there. Secondly, application based questions can be there, which means that, okay, the principle has been explained. Now, how well you can apply those principles to the legal problem that has been given, that is something which you have to attempt those questions on. And finally, inference based question. Based question means that you have to, the information is not directly given to you in the passage, or it is not there in the questions as well. You have to deduce meaning of something based on what all information is given in the passage to you, right? So now that deduction based questions, analytical questions, and inference based questions are slightly technical, right? And it might take you some time to solve them as well, but yes, these type of questions are also tested, are also asked. So whenever you read the passage and whenever you have to approach any question, the first thing that you have to identify is how well, or how well you have understood the law, and secondly, what type of question is being asked. If you identify the type of question correctly, automatically your approach to answer the same will improve. Okay, let's proceed ahead. A lot of times, most of the students who are appearing for CLAT, they get stuck at 18 to 20 marks. And that is very common. That is common because they are busy wasting their time and energy on things which are otherwise not being tested a lot, right? So now what are the things that are going wrong with those students? Let's understand first of all the same. First is outside legal knowledge. See, like I've already mentioned, it is not a test of your existing knowledge. It is not a test of how well do you understand law already, or how much law do you know. Even if you're coming from a legal background, let's say there are a lot of lawyers in your family and you know about IPC, you know about CRPC, you know about constitution, this exam doesn't care about the same at all. And sometimes a lot of students, they're like, oh, acha, I'll apply my existing knowledge to this. And like I mentioned, that's not something which is required. And in that overconfidence, they sort of mark the question incorrect. Secondly, they assume extra facts. Reading between the lines is something which is not required in the exam, right? The passage is there, and the passage in itself is your Bible. All the questions that have to be answered should be based on the passage itself. Unless it's an inference based question, right? There you have to read between the lines, but otherwise, reading between the lines is not something which is required in conceptual questions, not required in application based questions as well. And ignoring keywords. See, a lot of times there are going to be some words which can change the meaning of the entire principle. And that is something very important for you to identify. If you are not identifying those keywords, then it will become really difficult for you to understand those questions properly. Sometimes I've seen students who are in little haste, they read the question incorrectly, the word not or the word only is there, and they somehow avoided it. They ignored it, or they somehow missed on the same. Automatically, the option that they'll be opting for will be incorrect in that case, right? So, ignoring such keywords can also be a wrong thing for you to do. And then comes random attempting. This happens when you're not sure of the answer, but you just want to increase the number of attempts. And in that entire situation, what do you start doing? Just for the sake of increasing the number of attempts, you randomly start opting any option that is there. Now, this is an exam with negative marking. If you will give any incorrect answer, you will lose 0.25 marks, and that's not something which you can afford, because this is a highly competitive exam, and even one incorrect answer or loss of those 0.25 marks also can cost you a lot of ranks, can really significantly reduce your rank, and that's not something which you would want. So random attempting is something which definitely has to be avoided, right? So if you're not sure of the options, you can just leave it for a while, come back to it if you have time, but do not take wild guesses. That might not work really well in CLAT, because that doesn't work really well anyway. Okay, so now let's understand, if you really have to score 25 plus marks in this exam, what is something that you should be doing? First of all, identify the principle. Read the passage carefully. There is absolutely no alternative to reading. Legal reasoning passages have most of the answers in them. If you have read the passage carefully, you will be able to answer a lot of questions. So read carefully. Reading, give that passage the time it deserves. Read carefully, and not reading it just for the sake of reading it to understand what all has been given there. Read and find what law, what legal principle, what rule is being discussed. Identification of the principle is the first thing that you have to do, and the most important thing as well. Why? Because if you identify the law incorrect, you will also mark the options incorrect, and that's not something which you can afford. So, identify the principle first of all. Then, secondly, identify the material facts. These facts you might find in the comprehension itself, or you might find it in the passage. In the questions, right? So, what all situations have been given to you, what all different facts have been given to you, understand those facts carefully. If you have misread it, or if you have misunderstood the facts, you will not be able to apply the principle properly. And let's say you've understood the principle properly, right? You know what is the principle about, what is the law is talking about. But when it comes to understanding the fact, you misunderstood it, or you misread it, you skipped some important words, you omitted to completely reading it, and then what? What is even the point of now you knowing the rule, knowing the principle, right? So in that case, give those facts also the time that it deserve. Identify the same, identify things which are important, facts that you can skip, avoid them. Facts which are going to be base of the entire answer, please identify the same. And match the principle with the facts. When you have to finally apply that principle to the fact, you have to first of all match those principle with the facts and then apply it, right? Okay, moving ahead. Now let's understand what has to be done in detail, okay? So now identification of the principle. Identification of the principle, what does that mean? Like I've already explained it to you. You have to identify what law is being discussed and how it is being executed or being implemented in the society otherwise, because most of your answers will be based on the same. To understand it better, there are going to be some keywords which we use a lot in the field of law, which directly tells us about the kind of principle that is being discussed, right? So these principles are these keywords are intention, consent, negligence, reasonable care, harm, liability, and such more legal keywords, which automatically tells us that, okay, this is something most of the questions are going to be around. So if you are someone who understand the concept of consent or intention or negligence, otherwise, it's going to be much easier for you to answer the questions overall. Right, so identification of these keywords are something which is very important. So identify the keywords in the principle and underline it, internalize it, and apply it without any deviation. Okay, moving ahead. identification of material facts. Now, material facts means facts which are relevant, facts which can be important to finally answer the questions. Facts which are not relevant, which are insignificant, that is something which you can avoid. So any facts that is going to affect liability, which is changing, who is responsible, how is he responsible, those facts are important. Now let's say we said that A killed B, right? A killed B by shooting him, right? But so now we know this for a fact that okay, A has killed B by shooting him. Facts. One material fact that that you somehow come across is that A killed B, but A is below the age of 7 years. Now this is a material fact. The age is a material fact here. So why it is material? Because it changes the liability overall. Law says that anybody below the age of 7 cannot be punished for any crime that he or she has done. Now, this is a material fact. His age is a material fact, right? So, in that case, that has to be identified what all facts can change the overall liability of a person under the law and things which are avoidable. Now, let's say A's name was Akash and the person that was killed's name was Bhushan, right? So, this doesn't matter. It doesn't really matter what are their names. We can avoid that, right? So their names, what is their story, what were their emotions around the same. Probably that is something which is not material and that's something which we can avoid. So whenever you have to check if a fact is material or not, you have to think about the same that if this fact, if I remove this fact from the story, is this going to change the meaning or is it going to change the situation or not? If you can identify the same, if it is changing the entire liability, then please consider it a material fact. If no change is happening in the story even after removal of those certain things, then it is not a material fact and you can avoid it. You do not have to waste your time understanding those or memorizing those facts or using those facts in answering your questions. Okay. Then you have to match the principle with the facts. Now, uh, one really important thing for CLAD that you have to understand is that you do not have to go beyond the facts. Even if you think that, okay, probably this might have happened, but if you're not sure about the same and if that's not expressly mentioned in the passage, you do not have to rely on the same. Right? So, what is important? That you stick to the facts. Do not assume any new facts. Do not use any outside law and do not apply your moral judgment. It doesn't matter if you think it is right or wrong. If the passage is saying that, okay, this is the crime, this is the rule, this is how it has been breached, we'll stick to the same. We are not going to create any new information on our own. That passage is going to be our Bible. All right. So just match those facts that way. Okay. Next is that whenever you have options with you, which look identical or maybe see if you know the answer to the question, then it's the best thing ever, right? Then it's pretty much easy for you to just answer the question and get away with the same. But let's say you do not know the question, you do not know the answer, and you just do not want to take a wild guess also. So rather than taking a wild guess, it is always suggested that you should be using an elimination strategy. Now what does that mean? Elimination strategy means that you have to first of all um, identify what all options are there and most possible incorrect options has to be first of all removed, right? So now what does it mean? Every question is going to have four options, right? So there is only one correct answer that is there. Now you have to first of all identify. Okay, just give me 2 seconds. We'll just quickly get this thing fixed and we'll resume the live in 2 more minutes. Right. Okay, sorry for the glitch, folks. Let's continue. All right, so I was telling you about the elimination strategy. Now, what does that mean? Elimination strategy basically means that, okay, if there are four options given to you, right? So now in that case, you have to eliminate the most possible two incorrect options first of all, so that there is only two options left with you, which you can choose the correct option from, and you can then select the correct option, right? So two things that you have to do is you have to eliminate, first of all, you have to eliminate the most possible two incorrect options, and then the two options that are remaining with you, you have to select correct one among that. Okay, proceeding ahead. When it comes to questions, especially from questions that are based on criminal law, few keywords which are going to be really important for you is words like intentionally, knowingly, negligently, reasonable, dishonestly, and voluntarily. Why? Because these keywords, they decide the intention. And when it comes to application based questions, the intention is going to be really, really important, right? So intention, you can only these keywords, these single words are going to tell you what is going to be the intention of um, the person that is being discussed in that particular situation. So for application based questions, identifying these keywords is going to decide what is going to be the intention overall. All right. And a few mistakes that people usually make when it comes to attempting legal reasoning question, first of all, they use their external knowledge from IPC, which is, like I already mentioned, is not required. And they choose their moral answers. See, if it was about moral values, everything will be wrong and everything will be right. So we do not consider moral values at all whenever it comes to answering legal reasoning questions. So you do not have to opt options, or you do not have to opt answers based on what you think is correct. We have to be more particular about what the law is saying and what the law in the passage specifically is saying, and nothing about your moral values is going to be useful here. Do not ignore the keywords. All the keywords that we have discussed so far, please do not avoid the same, and attempt in order. Try to attempt the harder inference based questions first, because that is going to take you much time, and um, do not over attempt, right? The accuracy overall should be 50%, right? If you will attempt every question that is there, there is a possibility that you might give a lot of incorrect options as well. And that is not something which you should actually look out for. So do not over attempt your questions at all. Okay. So, right. So now very quickly, we are going to understand a few strategies based on time management, right? So now you should be giving at least 2 minutes, 2 to 3 minutes maximum for reading the passage. This much more than this much of time is not required. Every question should you should try to answer every question within 45 seconds to 1 minute. You see, you might have to give more time to sections like quant or logical reasoning. In that case, if you save your time in sections like legal reasoning and GK and CA, it's going to be easier for you that way, right? So 45 seconds to 1 minute, that's going to be the case. 7 minutes should be overall for the entire passage, including reading, answering the questions, eliminating everything. It should be at least it should be not more than 7 minutes, and overall section should be completed within 35 minutes, right? So when it comes to scoring well in legal reasoning, safe target is going to be 26 to 28 questions, right? So that you can actually score 25 plus marks. And your aim should be to get at least 20 to 25 questions correct. If you are going to apply this simple things that we have shared with you, it is going to be quite easy, quite useful for you to score well in the legal reasoning section. So yes, that was something I had to share with you today. You can tell me if you have any further questions. I'll be more than happy to take up your questions. If no questions, then it was really nice having you all here. And thank you so much, everyone, for joining. I'll see you all next Friday with more informative content. All right. Thank you so much, everyone. Have a great weekend ahead.